adjudication. The consequences of that principle are that one state may legally claim the right to remain judge in a dispute in which the rights of another state are involved. The second consequence is that political rights are not enforceable on demand in community which is seen, at least by certain theorists, as rule of law community. So this paper is trying to examine the Dworkin's methodology and how that methodology can be used to somehow maybe more even justify the abolishment of these principle-only suitings. The rejection of this principle depends on political responsibility of governmental officials who are acting in international relations, and of course on responsibility of community of states as a whole, if there is any kind of responsibility. So the first question is, do governmental officials which represent nations in international relations have the political responsibility to submit disputes to international adjudication in case of these disputes? The second question is whether the international community as a whole and under which conditions have this collective responsibility to secure the rights enforceable on demand. So, in approach to looking what are the standards according to which political or governmental officials should follow in international relations, there are two approaches. The first approach is to look for methodologies, to look for what are the practices of the states. This could be a problem for Lauterbach, because I'm relying all the time to Lauterbach's position, who is trying to justify why this principle is not in accordance with international law. Problem for Lauterbach is obvious because the practice is against his intent. So the practice of states at the moment is that omnis juris res sua is basically the law. So he accepts that according to current situation of conventions in international law, there is no room for compulsory adjudication. But he assumes that such practice is wrong and contrary to the idea of the law itself. So this now takes us to the second approach, which basically enables to establish legal doctrine which is not necessarily completely supported by the practice of the states. So the idea in the background of this method is that though the practice of countries or practice of states can be neglected if it is contrary to the aims of international community. So what is important about Dworkin and Lauterbach, because there are some similarities between those two, is that they do not completely reject the practice of countries, because then it would be the pure natural law theory. They take in consideration the practice. For example, in municipal law, Dworkin is of course taking into account what legislation is saying, what is the law, but at the same time the court can, in some circumstances, put that act aside if the implementation of that act will be against the integrity of law. In international law, you cannot legislation. What Dworkin is introducing is then principle of silence, which helps him to identify the norm which is widely accepted by the countries. What he's doing next is to, once he identified that practice, he's trying to compare that with the aims of the community. So this is the similarity between Dworkin and Lauterbach. They're doing the same thing. For both authors, the international law consists of such social practice, but also of the aims of the law. So Dworkin uses this methodology in international law to justify humanitarian intervention. So he justified that even if the Security Council did not make decision to go in that intervention. States have the rights and obligation to intervene in the case of breaches of humanitarian law. So the question is, can we use that to help Lauterpacht, to broaden that, to use that argument to help him in a way to justify why the principle of omniscience is not according to the law. The problem is that there are some objections. The first objection is that applicable to international law at all. So the first problem that you don't have institutional arrangements in international law that you have in national law. The problem with the legislation is augmented by the principle of silence. What is the situation with adjudication? There is no adjudication in international law, and Dworkin himself says that this is the condition for the law. So what he says, he says that let's imagine that court, and then let's try to see what is the law, guessing what the court will decide in each of cases. So someone can think this is fiction, but at the end we have heard some cases that this kind of methodology can be used even in national constitutional court, but also in an international court. The second problem is that Dworkin is talking about associated obligations. This is not kind of, international community is not kind of community where you can apply this. This is not, Dworkin is constructed for individuals in political community, not for states in community of states. In short, what he did is basically to say, okay, this is not that kind of association, but we can compare that, we can make some parallelism. And the most important moment is that international community also legitimizes the force, coercive power. It gives to the states the power to legitimately coerce individuals in the states. So the international community should have some kind of legitimacy, and states should have legitimacy not only towards its own citizens, but also regarding the citizens of other countries. So we come to the question then of what is internal character of international community. Because Dworkin makes for each relations associations for friendship, for lovers, for family, there is some kind of internal character of that relationships. So what about international community? He says there are two purposes of international community. The one is protection of peace by banning external intervention, and the second one is protection of human rights. Lauterpacht is going a little bit farther. So he's trying to say that not only that, but also the rule of law is part of that internal character of international law, which can be problematic, because in that sense now he is maybe too far, he goes too far from the practice, because social practice is not like that. Maybe he goes too far from that position. So he's in danger to distance himself too far from the existing social practice, and in that way he makes his background principles of responsibility maybe utopian aims. So we can also question ourselves, do governmental officials have any responsibilities to the citizens of other countries besides humanitarian intervention, besides to react when another state is forcing other states? Maybe we can try with Dworkin's principle of no harm, but then the Westphalian system has determined what is the harm for other citizens of other countries. So it is banned on threat and force, and it is banned on violation of human rights. All other disputes are not responsibility of the community to react or other states to react on that. So I think it can still be justified that this system is legitimate, because we have another principle, and that's the principle in international law of reciprocity, which is the basic principle of international law. So as far as states can react on and reciprocally answer on the actions of other states, then it's okay. The only problem is that if this principle of self-help is somehow limited, so that the states are not in position to react on the acts of other states. It can be, for example, relevant for the relations of particular associations of countries, for example, EU, but also it can be relevant for the problem with membership. If the membership to EU, for example, is conditioned by political consensus, and under the thesis that this community is important for the people of life of that state, then this kind of pressure can be maybe questioned as the legitimate force of the community towards that state. So in short.
All right, thank you for this interesting presentation. Now the floor is open. Questions? Any questions? Then I'll try to make one. Well, you base your thesis on presumption then, as far as I understand it, that international law and national legal systems are two separate legal systems, and that international law is based on the same principles as a national system, no rule of law, basic values. So my question to you would be, what would happen to your thesis if you would argue that international law and national law, they are just one part of a normative system which exists in the world?
Well, this is not my thesis, just what I'm trying is my focusing on compulsory education. So I'm trying to see, is there any possibility to justify compulsory education in international law? Lauterpacht and Kelsen deals with that question a lot. So Lauterpacht, I think that he made a very reasonable argumentation why compulsory education should be introduced in international law. He said this is contrary to the fundamental principles of the law. For example, the equality of states. If the states are equal in the international law, then one state cannot be judged in its own matter when the rights of other states are involved. That's his argumentation. So basically, but I think that he has a problem with his theory. So I'm just investigating, can we use Dworkin and him to justify that? And at the end, I think that it's not possible. The international community cannot say that it is justified to introduce compulsory education. The second step is that maybe in the European Union and in Europe as a specific legal order, this can be the case. So this is the next step to investigate.
Thanks. Maria.
Okay, I'll try that one, which is, a colleague told me, and you will correct if I misunderstood this, that self-determination is now recognized as a norm of customary international law, which is even enforceable against the state.
Who will be so?
Self-determination is now recognized as a norm of customary international law, which is enforceable against the state. So is this, how would you conceive of that? How could that be compulsorily enforced against the state, or what would you?
This is a very good question, and that this shows basically the Lauterpacht himself has a theory on not only self-determination, but that each states, we can find the criteria for recognition of states themselves. So it's objective criteria, and we have to have that criteria in international law. The international law is going to be called law at all. So basically, it's only the declaration of states that they recognize other states, but it doesn't matter basically because there is criteria which is objective. It's constitutive. It's not constitutive act. It's declarative act for the state. So this is what Lauterpacht is trying to do all the time. But I think he's going a little bit too far from that social practice. So what is the principle in international law regarding the self-determination or recognition of states? Is it only the practice of states? or we have something outside of that. So how to make this, he's calling that feedback loop, how to make this interaction and find what the international law is.
Thank you.
Mario, very simple question. Does international law claims to be a legitimate authority? And if it does, how it claims this authority when there is no compulsory litigation? Are there any other ways to claim authority even without this compulsory litigation?
Okay, one aspect of the PhD thesis will be with the RAS and normative aspects of that. In this part, I can only say from this paper and from this kind of approach of working in Lauter part, that working saying we have a Westphalian system, and this system have two aims: to protect states from the force from outside and to protect individuals from their own states. So the system is legitimate only if the system can do that, if it is taking care about these two risks. If not, then there is no legitimacy for that system. That's why Dworkin, I think, is trying to justify why USA can intervene in Syria, for example, even if Council of Security does not approve that. Because this is the aim of the Westphalian system. They should do that. The question for my part, this is pretty much clear for me. The question is, now Lauterpacht is going to step farther. He's saying not only that, but also rule of law, international is the part of that aim. And then I'm not sure that this is the request that you can pose to international community. Maybe to European Union, yes, but for international community, no.
Thanks a lot, Mario. The last presentation in this panel by Robert Smreka, European Scholar.
Thank you. I'll be very short, I assure you. So my idea was to open an issue about the protection of fundamental rights as a criteria for the implementation of Security Council resolutions, namely considering targeted sanctions and counter-terrorism sanctions. The United Nations is a sui generis subject of international law, which has built its reputation and extraordinary legitimacy on the basis of an almost universal state membership and high ideals set out in the Charter. The principal goal, which has led the international community through its creation, is at the same time the principal ratio of this organization, the safeguarding of international peace, the protection of human rights, and the common welfare of the entire human species. To successfully fulfill this massive task, it has been awarded exceptional powers, which have to be employed wisely. These unique features of the UN are specified in Article 25 and 103 of the Charter. And namely, the Article 25 says that the members of the UN agree to accept and carry out the decisions of the Security Council in accordance with the present Charter. And the Article 103 said that in the event of a conflict between the obligation of the members of the United Nations under the present Charter and their obligations under any other international agreement, the obligations under the present Charter shall prevail. The UN law has therefore the superior position in international law and the priority, even supremacy, over any other legal system. Chapter 7 of the UN Charter defines the measures the Security Council may apply in order to meet its role of the words peacekeeper. And Article 39 of the UN Charter states that the Security Council shall determine the existence of any threat to the peace, breach of the peace, or act of aggression, and shall make recommendations or decide what measures shall be taken. And Article 25 also says Inter alia, in discharging these duties, the Security Council shall act in accordance with the purposes and principles of the United Nations. Having said so, we could easily advocate that the Security Council has thus the discretion to decide when to act and, which is most interesting, what measures to implement. State-orientated general economic sanctions have been the most common measure engaged in the past, but due to their inefficiency and massive side effects on the affected state's population, by the end of the 90s they have been replaced by targeted or smart sanctions. And this evolution has also been provoked by the changed nature of the peace-threatening activities of global terrorism, and individuals have thus definitely became subjects of international law. But targeted sanctions have not been contemplated by UN constituent states, and doubts about their legitimacy arise. The issue gets even more controversial considering the fact that the UN does not have the necessary organizational structure nor regulation to fully meet the standards of human rights protection for the affected individuals, commonly known as due process. Individuals listed on the counter-terrorist lists are not provided with some of the very basic process rights, for example, the right to fair hearing. It is well known that the protection of fundamental rights is embodied in a series of UN acts and therefore represents materia constitutionis of the UN law. Having said so, it is clear that all UN organs, Security Council included, are thus bound to UN law. It is the extremely wide powers and rights of discretion put before the Security Councils, the obligation to execute them within the UN constitutional and legal framework. UN has thus found itself in a paradoxical situation. While protecting peace and human rights, it is neglecting and violating the latter. It has been faced with a seemingly irresolvable conundrum and has had to choose between safety on the one hand and freedom on the other. The above-mentioned dilemma became even more evident while implementing UN Security Council resolutions, which set up targeted sanctions, as I mentioned before. Different human rights protection standards in various national, subnational, and regional legal systems represent serious obstacles in the implementation process of these sanctions, thus preventing the simultaneous global effect on the war against terrorism in the name of the human rights protection. This controversial situation has manifested in a crystal clear manner in the Cadi case, which faced the Court of Justice of the European Union with an extremely delicate task: find the proper approach which would, on the one hand, preserve the superior character of UN Security Council resolutions while protecting fundamental human rights as defined by legal standards in Europe, especially by EU law and the European Convention of Human Rights on the other. Regardless of the apparently diametrically opposed approaches engaged by both the Court of First Instance and the European Court of Justice, it is possible to find a common fil rouge in the above-mentioned decisions. A set of norms which are placed in a hierarchical position above UN law exist, and they set up boundaries to UN decisions. If the latter exceeds these limits, they are illegal. Therefore, a doctrinal question arises: are fundamental human rights part of these higher norms? What is their relation versus use cogens, and how do different standards of human rights protection define the relationship between UN law on the one hand and national or subnational legal systems on the other? Is this relation hierarchical, conditionally hierarchical, or barely heterarchical? It is my view that respect for fundamental rights and use cogens on a case-by-case basis decisively influences the relationship between UN law and other legal systems, which is therefore conditionally hierarchical. The principle of protection of fundamental human rights has become part of customary international law, and it is thus set before the international community as a universal imperative. It is clear that some human rights can be temporarily restricted, but they are other human rights that have, in my opinion, reached the status of international misconduct, meaning that no derogation under any condition is possible and acceptable. Could we find in this statement a hint of a hierarchical structure in international law which denies the supreme position of UN law? It is my view, while considering the position of the UN law within its jurisdiction, we could argue that there are two sets of norms which have a hierarchical higher position over UN law. The first one is formed by these human rights which can be temporarily restricted, and the second is jus cogens, which has the supreme position within international law and embodies some human rights that cannot be derogated under any circumstances. The respect for human rights and the proper sustainable balance between security and freedom is set before all UN bodies as the supreme principle. The violation of this principle can raise the question whether such law could be defined as no law in the Radbruch sense. And that would be what
Thank you, Robert. Let's start with questions.
Starting from this last remark about the peak position of jus cogens in this hypothetical or actual hierarchy in the sources of international law, I don't want to open a can of worms and try to define what jus cogens is. But last time I checked, jus cogens is generally conceived to comprise war crimes, crimes against humanity, maybe self-determination, prohibition of international crimes at large, prohibition of torture, genocide, and ethnic cleansing. But all of this is related in a way substantially, but it's not protection of fundamental rights. I still have to see where jus cogens is attributed to a rule of fundamental right protection. Even right to life is not in itself jus cogens. I agree that it's fundamental, it's a rule of customary law. You can say that it's a general principle of the system, both at the international level and in Europe, and I assume in most constitutional systems, but it's still not jus cogens. So, though we know that genocide, you cannot really conceive the prohibition of genocide to be anything less than jus cogens. Protection of fundamental right is not really in the category, or at least it's not commonly considered to be jus cogens. So we have a problem there with the hierarchy, because then we have to assume that this kind of obligation, even if it's customary, if it's general principle, is more or less the same stepping as conventional and custom. So we would have to come with a distinction that is more substantive. Protection of fundamental rights is better than normal treaty law because of its substance. It's an axiomatic view, rather than saying it's different in nature. Because not being jus cogens wouldn't make it, higher as a matter of system of sources. And which is the problem that arose with CARI as well, because in CARI 1, I'm talking of CARI 1. And the General Court, at the time it was the Tribunal of First Instance, tried to use jus cogens as a limit. I only would conceive it possible to go against UN Security Council resolutions and acts implementing them if it were a matter of jus cogens. But as they recognized, there wasn't a case of jus cogens because we were dealing with the right to property, right to judicial protection, and right to fair treatment and due process. So none of this was inherently jus cogens, and that's why the tribunal said, in the end we have to respect this. And this is why we can see as a problem the Court of Justice decision, because they didn't base their reasoning on jus cogens, on some supposed rule of jus cogens that were violated. They simply said that in the European system, there were some fundamental European Union rights that could not be threatened, which is what you would define jus cogens at the international level, but there's no such thing as European Union jus cogens, as far as we know. So unless we come up with this new category, I agree with you that we have a problem where to put human rights exactly.
Well, depends on how you look at the position of individuals within the international law. That by introducing targeted sanctions or even targeted bombing, which has become now a common practice, does the physical person became part of international law? Is it just an object or a subject as well? If it's part of international law as a subject, then does it has any rights within the international law? And does this right, does use cognizance then include the right for life, for example, as well? So